You can keep your driver's license after a DUI in Oklahoma, but there are things you must do. Driver's license suspension is a standard component of DUI punishment in Oklahoma. Some states feature punitive suspensions. These laws aim to take drunk drivers off the streets. Other states, including Oklahoma, focus on rehabilitative suspensions. The Impaired Driver Accountability Program, the Sooner State's version of a rehabilitative driver's license suspension, is unique in several ways. However, before the state can suspend your license following a DUI arrest, authorities must comply with the Constitution's due process requirement. In this case, due process requires notice and hearing. Requesting this hearing is usually a good idea, regardless of the circumstances. Either way, a Tulsa DUI lawyer is an important part of the process. IDAP clerks routinely reject applications over technicalities. Experienced attorneys not only know how to complete AIDA applications, they know what to say and what to omit in these applications. Additionally, at the administrative driver's license suspension hearing, an attorney is a strong voice for you. ALR driver's license, suspension in Oklahoma. The law on this point changed in 2019. After a DUI arrest, defendants only have 15 days to request a license suspension hearing. This notice is usually buried in a mountain of arrest paperwork, so it is easy to miss. On the 31st day, the entire license suspension period automatically goes into effect. These periods are 180 days for a first offense, 365 days for a second offense, and 1,095 days, 3 years, for a third offense. Typically, the triggering event could be a DUI arrest or a refusal to provide a chemical sample. In either situation, at an ALR hearing, the state must establish probable cause for the arrest or chemical test demand. Results of the field sobriety tests, such as the DUI eye test, generally provide the necessary level of proof in these matters. Probable cause is a lower standard of evidence than beyond a reasonable doubt, which is the standard of proof at trial. Therefore, the officer's subjective opinion that the defendant failed the tests is usually sufficient. Additionally, an ALR hearing is not a criminal proceeding. Therefore, some normal Fifth and Sixth Amendment rights don't apply in these hearings. Furthermore, the administrative law judge is usually a paid DMV employee who serves as judge and jury in your case. So, the deck is stacked against defendants. However, it is not impossible to win these hearings. Furthermore, at the hearing, your Tulsa DUI lawyer has a chance to cross-examine the arresting officer under oath. This invaluable discovery is often otherwise unavailable in misdemeanor cases. IDAP Program Overview. In early 2019, Oklahoma attempted to streamline the process for drivers in our state after a DUI charge. The IDAP program is supposed to be a kind of diversion program. The Impaired Driver Accountability Program is intended to allow you to continue driving after a DUI without your license actually being suspended. Moreover, there's usually no risk. An adverse result at the ALR hearing just means the maximum license suspension. That would have happened anyway. Furthermore, the IDAP program is usually still an option. This program allows motorists to keep driving during the license suspension period. An attorney can help you complete the application form. Defendants must also pay a $250 processing fee. Additionally, defendants are financially responsible for ignition interlock device installation and monitoring. An IID is a portable breathalyzer attached to the vehicle's ignition. If the driver's BAC level is above a preset level, usually 0.04, the vehicle will not start. While the car is running, the driver must periodically submit to additional tests. Obviously, it's not always possible to immediately pull over and blow into a breathalyzer. Too many rolling refusals, however, or a dolling failure disables the ignition. In other words, the car will not start again. Once the IID period ends, the safety suspension does not appear on the defendant's driving record, and the defendant need not pay a reinstatement fee. However, the defendant must usually provide proof of insurance and jump through a few other hoops. Oklahoma. IDAP lawyers. To learn more about IDAP in Oklahoma, contact an experienced criminal defense attorney today. Hiring a criminal defense attorney is important for ensuring that your rights are protected and your case is tried fairly. For a free consultation with an experienced criminal defense attorney in Tulsa, contact Kania Law Office. We routinely handle matters in Osage County and nearby jurisdictions. To learn more about how Kania Law Office can help you with your case, call us at 918-743-2233 or visit us online at kanialaw.com.